Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their opinions, and they shall be heard.
Thank you. Please be seated. The first case on for argument today is case 60, People versus Bradley. Counsel, can you hear us? Counsel, can you hear us?
Yes.
Very good. Okay, we can hear you also. Counsel, please proceed.
Yes.
But before you do, let me ask a kind of a simple question. Your client's pronouns are she and her, is that correct? I'm not hearing you.
I believe so.
Yes, and so I'm going to add, that's what...
Can you hear me?
Yes, I can now. That's my reading of the record, and so I'd ask both counsel to adhere to those pronouns during oral argument, and thank you for that. Please proceed.
That's fine. Yes, this is an appeal from a conviction for assault. I would like to address first of all the issue of proceeding on direct appeal rather than a 440 motion, and I believe that all of the evidence that we don't need to develop any new evidence so that we can proceed directly with a direct appeal.
Counsel, I'm going to interrupt your argument.
Here is
Counsel, I'm going to interrupt your argument. We're having a tough time, I think, hearing you. It's breaking up, and I'm not sure whether or not you need to get closer to the mic and stay in one place, but let's try something different, because what's happening is not working. Now you're not coming through at all. No. Let's do this, counsel. Can you hear me? If you can hear me, why don't you phone in and we'll get you on the phone as opposed to the video, because this hookup's not working. We can't hear you. We still can't hear you. There's a phone
What's the number
number
to dial?
Yeah, there's a phone number to call. It should be on the information that you've received. I don't have it in front of me. I'd ask our IT department if they could reach out to the council.
Judge, we can reach out and do you want to come back to this case or?
Yes, let's do this. We're going to recall case 60 and we'll see if we get a better connection. Thank you.
We'll let Terrence know when he's back.
Very good. Appreciate that. Case 61, People versus Watkins. We'll see if we have better luck. Counsel, can you hear us?
Yes, I can. Can you hear me, Your Honor?
Yes, we can, loud and clear, very good. Please
you.
proceed, please proceed.
May it please the court, Brian Schifrin on behalf of Patrick Watkins. Last month, the Court of Appeals in People v. Bay reversed the conviction and dismissed the charge because the people had failed to demonstrate that they acted with due diligence and made reasonable efforts to determine the existence of a 911 call prior to filing the original Certificate of Compliance, or COC, in that case. Consistent with that holding in People v. Bay, reversal and dismissal are required in this case, where the people never set forth any efforts to determine the existence of a 911 call until August of 2022, nearly a year after the commencement of the proceedings and 10 months after the filing of the original Certificate of Compliance.
Counsel, does it matter if there's no indication of the police report or otherwise that a 911 call was even made? In other words, are the police required in every case to request 911 records? Is that your argument?
It's pretty simple. The answer is yes, and I'll go through it. In Bay, there was nothing in the police reports either, and in Bay, the argument of the people was, well, they had good faith. They relied on the police reports. And what the Court of Appeals held in Bay is that good faith is necessary, but not sufficient. It must also be established that reasonable efforts were made to determine the existence of materials. And in Bay, as in this case, the explanation of the prosecutor was, well, they knew that the parent went directly to government officials. And that's what happened over here. The parents went directly to Bavona. And the court held that was not the requisite due diligence. So yes, either the police or law enforcement in every case must contact the agency that keeps 911 records, because the 911 records are mandatory disclosure discovery under 24520 subdivision 1G. In this case, neither the DA nor the police ever contacted the Office of Emergency Communication until August of 2022, again, nearly a year late. The day they contacted, they immediately got the records. So this is easy. These records are easy to obtain. So, and you can't rely on police reports. We learned that in Bay, that situation there. Because of the failure to make any efforts to locate it, they relied, well, they didn't think there were any. The Court of Appeals in Bay held that was not the requisite due diligence. It wasn't the requisite due diligence here. When the efforts were finally made, it was far too late. It was way after 30 time had expired. And of course, under 245-50 subdivision 3 and 3030 subdivision 5, with the Certificate of Compliance is improper, there's no readiness, and therefore there was no readiness for a year, far beyond the 6-month period. I should point out further, in Bay, the Court of Appeals made clear that the focus on readiness is on the initial original Certificate of Compliance, that not the supplemental Certificate of Compliance, because the supplemental Certificate of Compliance in Bay, as in Mr. Watkins' case, was filed way too late. The question was whether they had made due diligence and reasonable efforts prior to the filing, and they didn't. They said, well,
Counselor, going back to Justice Whalen's question, aren't you basically arguing that in all instances they have to make an inquiry that there was a 911 call? Because in this record there was no indication. The father never stated it, wasn't in the police reports, so it's almost like there's a checklist they have to follow.
Actually, there is. And again, that's exactly what happened in Bay. There was nothing in the police reports showing there was a 911 call. The parent in Bay went directly to the police. And yet, prior to doing so in Bay, as in this case, there were 911 calls. So yes, either the police or the prosecutor, because there's an obligation under 1G to turn over 911 calls, has to make reasonable efforts to ascertain the existence. Just looking at police reports and saying not mentioning the police report is not the requisite due diligence. That issue was litigated and decided by the Court of Appeals a month ago.
We'll take a look at that, counsel. Do you want to address point 4?
Sure. In point 4, and after I do that, like if possible, I'd like to go back. But in point 4, we're urging that the imposition of a 27-year sentence in this case was harsh and excessive, given the lack of any prior record and given the player of the two most serious charges, and given also his own background, my client's background, which is set forth in point 4 of mental health issues and other issues, and also given the nature of the verdict was. The jury obviously was troubled by the issues of credibility with the complainant because they couldn't reach a verdict on 2 of the counts. I can go back real quickly on that because I think it's relevant to point 4. On point 3, we urge that the verdict was against the weight of the evidence. This is a case, again, there was no physical or medical corroboration. There were no admissions. There were no witnesses. There was no observed change of behavior. So the only thing that we have is you have to determine the credibility of the complainant. The ways you can determine the credibility is look at the things that you could tell for sure if she's telling the truth or not. She was asked, did you tell Bravona that you had screamed for 5 minutes during the first incident? She testified she did not. And yet the Rochester police investigator who was present at that witness testified, in fact, she did. She was asked, did you tell Bravona that afterwards it was cleaned up with a spray and a towel? She said, no, I did not. Again, we know that's not true from the RPD investigator. So the ways that we can measure her credibility, we know it's not true. She also said she was bleeding and was while wearing a nightgown, still bleeding when he went to bed, yet her mother never found any blood on the sheets or on the nightgown. She claimed that he was screaming to Bravona, was screaming for 5 minutes in a small house. No one responded. The last incident in which she claimed that while she's in the upper bunk of a bunk bed and her sister's in the lower bunk, Mr. Watkins first engaged in oral sex with her while he was standing and she's in the upper bunk and the sister's below her. And then he carried her down and put her next to her sister on the floor, raped her. Again, that makes no sense, which explains in part why the jury did not convict on the rape count. I think the verdict is against the weight of the evidence. And I think the verdict could be explained by the wrongful admission of prior bad act evidence of prior alleged sexual misconduct by Mr. Watkins to this complainant. This is in violation of the Court of Appeals holding in People v. Leonard, which is exactly on point. People v. Leonard, like this case, is a Monroe County sex case where the complainant and the defendant knew each other. There's no issue of identity, no issue of intent. The background was clear, and the Court of Appeals in Leonard held, first of all, it wasn't admissible for any of those factors, and to the extent that it might have been admissible for something other than propensity, which they said it wasn't, the prejudicial impact greatly outweighed the probative value. And that's what you have over here, except that the court below in this case didn't even weigh prejudice, never considered prejudice. I point to pages 171 and 172. After defense counsel argued first it wasn't probative and necessary, and then argued in any event prejudice outweighed probative value, the court admitted it for a variety of improper grounds, not even mentioning or balancing prejudice. That was error.
Counsel, you need to wrap up.
One final thing, if I go back to point 1, the people argue in point 1 that this issue was somehow waived because there wasn't a motion with respect to the supplemental COC. That's wrong in a number of respects. First of all, the day after the initial COC was filed, the day after, there was a motion filed with the people demanding that they look for 911 calls. And that answers both, by the way, Justice Whalen's question and Justice Greenwood's question. They were on actual notice one day after the original COC, look for 911 calls. They didn't do so. Second of all, the Court of Appeals in Bay reversed and dismissed when the motion was a motion to dismiss on a motion against the supplemental COC. Third of all, there was no duty to do so until May of 9th, 2022, when the statute was amended. And by then 30/30 time had already run. And finally, this issue, that argument was not made below, was not the basis for the decision below, and cannot be a basis for this court's decision. Thank you, Your Honors.
Thank you, Counsel.
Good morning. And not surprisingly, I have a different view of the highlights of People versus Bay. And contrary to what counsel seems to indicate, the Court of Appeal has made clear this is not a strict liability issue. If an item is not disclosed, it's not automatically a discovery violation. To the contrary, there are several factors that must be examined. And I submit to you in this case, the decision of the trial court finding both due diligence and good faith comports with Bay. And I draw the attention initially to the efforts made by the prosecutor to comply with discovery demands. There's absolutely no indication in this record that the prosecutor failed in any way to comply with his discovery obligation during the pendency of this case. The volume of discovery outstanding, there's no evidence there was any outstanding discovery other than this 911 tape. The missing material would not have been obvious. And I really want to draw the court's attention to the fact that this is not an armed robbery where you would expect a 911 call, or a burglary in process where you would expect a 911 call. This is a delayed disclosure of a continuing, basically what turned out to be a continuing course of sexual misconduct on the part of the defendant. So not only do you have the nature of the case, but also the paperwork, as opposed to many of the other cases relied upon by defendant, indicates that this case came to the police by virtue of Bavona. This isn't a situation where eventually, the parents just went to the police department and wanted to report this. The prosecutor had no basis to believe that there were any 911 calls here whatsoever. So therefore, and another factor, the DA had no basis to look for the police paperwork because there was evidence that this had been a direct disclosure to Bavona. And finally, once the prosecutor learned of the phone calls, he immediately got the needed documents, provided them defense counsel. I believe he found out on a Thursday. His attempts to get him to defense counsel on Friday failed. He did get them to him by Saturday. So I think that if you look at all these factors, I believe that the court's finding of due diligence and good faith was proper and is supported by the record. I'm just going to go in order really briefly with regard to the points. With regard to Molyneux, I don't believe the court's error, the ruling was error in and of itself, because I do believe it is indicative of motive. I think that this girl was targeted. I think that he clearly wanted to have this type of contact with her, that he, in essence, tried to normalize these type of situations to her. So I do think that the Molyneux evidence was relative to motive.
Do you think that with regard to both of the different pieces of evidence, you think they both?
I think the other involves relationship between the victim and the defendant. I think that these past instances just show that, there was a trust between the two of them that he had built up, and that, that is also a possible explanation for her delayed disclosure. With regard to the weight of the evidence, again, was she inconsistent? Absolutely. But you need to look at who our victim was, what she had been subjected to. The defendant, she also disclosed that the reason why she never disclosed is the defendant told her he would do the exact same thing to her little sister and her mother. She had no basis to believe that wouldn't happen. So I submit to you that, yes, there were inconsistencies in her testimony, but it did not render her testimony illogical, and that the verdict is supported by the weight of the evidence. With regard to the sentence, this was a substantial sentence for his criminal history, but his conduct was heinous, and I don't think anybody would discount that. The references to, mental health histories, learning disabilities, it's really rather vague. What we do know, he wasn't under any medication at the time. He certainly seemed very well capable of putting himself in situations where he could have access to this child, which I think is indicative of manipulative conduct on his part. And he also threatened the girl's family if she were ever to tell anyone. So while it is substantial, I believe that on this record, his conduct, his lack of remorse, that it is not harsh and excessive. Absent any questions, I'll rely on my brief.
Thank you, counsel.
Thank you.
Recalling case 60, People versus Bradley. I understand we're getting Mr. Giglio on the phone.
Yes, can you hear me now? Can you hear me?
I can. We can hear you. Thank you. Can you hear us?
Okay. Yes.
Let's
Sorry
start.
about that. May it please the court and
Please.
counsel, I'm ready to proceed, if that's okay.
Please do.
Okay. All right, this is a direct appeal in which we're alleging that the counsel was ineffective, trial counsel, for failing to request a charge of justification. First thing I'd like to do is address counsel's argument that we need to proceed with a 440 motion rather than a direct appeal. We believe that all of the evidence is in the trial record, all the testimony. We're not trying to develop any new testimony. The sole issue is whether counsel was ineffective for failing to request a justification charge. And our position is that there was no reason not to request a justification charge. Because
counsel, let me ask you
Yes.
that. Some of the reasons might be that the court asked counsel whether they'd like one, and counsel said no. That's one that jumps out at me right away, and that was from the very beginning of the trial. And that answer never changed. It was never asked for, and so therefore it was never given. And secondly, I'd like you to answer this question. The concept of justification, doesn't it go counter to the strategy at trial, which was that defendant was innocent of this crime?
Okay, addressing the justification charge, it can be argued in the alternative. Now, when you look at the evidence at trial, we have two witnesses that were at the scene, the victim as well as, I guess you would call her the co-defendant. And both of those two witnesses testified that the defendant did in fact stab the victim. So we have no witnesses that testified that the defendant did not in fact participate in the assault. So I think at that point we need to say, hey, why can't we argue in the alternative? Yes, I may have impeached the credibility of these two witnesses, but I have no witnesses on my side to say she didn't do anything. So I think we can go to the jury and say, hey, listen, even you may believe my client didn't stab her. Great, we're off there on that. But if you did in fact believe part of these witnesses, was she justified? And then I think when we look at justification, the prosecutor has to prove beyond a reasonable doubt that she was not in fact justified. And I think when you look at the weight of the evidence, it seems the victim was the initial aggressor in this action. There's evidence that the victim did stab the co-defendant in the neck to start the altercation. There was evidence that obviously that the victim went to the home of the defendant. So I think looking at the weight of the evidence, I don't think the prosecutor can establish, and the burden of proof would be beyond a reasonable doubt. I don't think the prosecutor can establish beyond a reasonable doubt that justification was not in fact in the
So
case.
counsel, in your view, there was no strategic reason for counsel not to have asked for this charge?
Exactly. I mean, there's no strategic reason because you can argue in the alternative, and it should have been argued in the alternative.
Counsel, let me follow up on Justice Bannister's question. Would it not be a strategic interest to simply avoid going to a jury with alternate theories? Isn't that in and of itself a strategic decision counsel could have made, that they didn't want to argue in the alternative to a jury because counsel felt that it would be ineffective?
I think each case should be fact specific regarding that issue as to whether we want to go to a jury and say, hey, listen, I'm going to put all my eggs in this basket. But I think if you look at the facts of this case, you have no witnesses on your side saying she wasn't there. So I don't see how you can say, it's not a hard rule. I think you really need to look at the facts of the case. And in this case, we have no witnesses that said she wasn't there or that she
Counsel, if the trial counsel had gone to the jury on the justification charge, as you're arguing they should have done in this case, and they were convicted, would you be here arguing that your client's position at trial was actual innocence and therefore counsel was wrong to not pursue actual innocence? And we'd be now arguing on that point?
If she was convicted of in spite of a justification charge, we'd be arguing that the weight of the evidence against justification or weight of the evidence for justification is overwhelming, and that the prosecutor carries the burden of proof, and that the indictment should be dismissed based on the weight. I think I have your argument. Thank you, counsel. Thank you.
Anything further?
No, thank you.
Okay, very good.
Good morning. May it please the court, Meredith Smith for the people. Justice Whalen, Justice Bannister, any of your questions covered my arguments. I think when you look at the totality of arguments and the way this trial was handled, defense counsel's strategy was clear from the beginning, and it certainly wasn't unreasonable. It wasn't a bad strategy. It was a strategy, and the burden here is on the defendant to explain an absence of strategic explanations, and it's just not there in this case. Thank you.
Thank you, Counsel. Case 62, People versus Newton. Proceed, Counsel.
Good morning, Jonathan Garvin for Bruce Newton. May it please the court. The first time the trial court uttered the words post-release supervision was seconds before it imposed sentence. Much too late for the defendant to make a motion to withdraw his plea. The trial court had a duty to advise Mr. Newton at the plea colloquy that as a direct consequence of admitting to a VOP violation, he would be subject to mandatory post-release supervision. The trial court's failure to do so violated due process and mandates that this court reverse his conviction. There is no question that you can look at the record, and the people are not contesting that the trial court did fail in its duty. And I do note that with the same judge, this court recently, last year, the People v. Bell involved the facts and the law are indistinguishable. Where there was a VOP admission, there was, and this court found that the same trial court's failure to advise of a direct consequence mandated a reversal of the conviction.
Now, my notes are indicating, and I want you to correct me if I've got the record wrong, because
Yes,
you'll know
Your
the
Honor.
record certainly better than I do. But it seems that 2 weeks prior to pleading guilty, he signed a cooperation agreement, and within the cooperation agreement, there was an acknowledgement or notice that the post-release supervision years would be applicable to the sentence. Does that make it, do I have the record right? And if I do, does that make a difference?
It does not make a difference, and you have the record right that there 2 weeks prior there was a plea agreement,
Cooperation agreement, right? Was it?
Well,
Do I have that wrong? It wasn't a
it's
cooperation?
the title is plea agreement, but then it's a few pages long. Then it's like a mixture of a plea and cooperation agreement, and part of the ambiguity in the language is the reason why that doesn't matter. And if you read the document carefully, it's not clear that that a defendant would know that by pleading, when you just zero in, what did he actually agree to? If he was successful, he would get a cap of 2 years, and there's no mention of post-release supervision. If he wasn't successful, it would be at the court's discretion. So if a defendant was relying on that pertinent section, he would not know, it's not clear that he was definitely going to get post-release supervision, even though in the beginning there's a full range is broad. So
I think I understand your argument. You're saying that, yes, that language was in there, but there was other language in there, and if you read that in total with what was being presented to the defendant, that it was ambiguous, and he could have very well understood he was just getting a 2-year cap and not the
and it was
post-release
very,
supervision.
I'm sorry, Your Honor, it was very likely that he would do that in this situation, because as this court found in Cornell, if you look at what happened, okay, first of all, the court didn't review the document to make sure that he understood, as we do in many cases that involve constitutional deprivations, including oral waivers of appeal. Just signing the document is not enough. It's important that the trial court goes through, did you understand it? Do you understand the terms? That hasn't been done. And because the trial court has a duty to make sure from the face of the record, this is a clear rule that works because it's a record-based rule where the trial court has a duty, a constitutional duty, to advise of direct consequences. And if the defendant is ignorant of a direct consequence because of a deficient colloquy, then every appellate division, Court of Appeals has said that that mandates reversal, and that's what happened here. And the court, even though, the people suggest that this was purposely, it's pure speculation that it was purposely not put on the record because the record doesn't say what the sentence was and doesn't say any direct consequences at all. But because he was cooperating, that it was done on purpose. And that is, first of all, that's speculative, but sensitive materials come up across trial courts all the time, and the court had options. It could have done what it did in 2012, where when the defendant first pled guilty, it's on the record, and in writing and on the record, what his actual plea is going to be. It's post-release supervision is right there. And so it's very easy to either, we cited some cases where the Nicholson case was a 440 case where whether the contract was on the record didn't matter because it was on a 440. The court could have just done its constitutional duty and just not mention that there was a written cooperation agreement, which is exactly what...
You said the court had options here. The court didn't exercise those options where we could have made a record that was sufficient to demonstrate that he was on notice of the post-release supervision time.
Which it did in 2012 and it didn't do here.
I think we have that argument, counsel.
Okay, so just about the... so there's really, two fundamental principles at play here. The first one we just went over, he's not on notice, he's not aware of post-release supervision. And there's the issue, there's a People v. Murray, there's a case where, because this is the argument is that there should have been preservation. But, until from the plea colloquy to the actual sentence, for all those 18 months, the court never mentions post-release supervision. And until the court does, the defendant is not under a duty to invite the court to add more time. It's the court's duty and to do that. And it's not incumbent on the defendant to make sure that he adds 3 years to a sentence. And so, at People v. Cornell, the court said, this is how why the defendant would not know in between those 18 months that post-release supervision was mandated because, we had the plea colloquy, because every time, all those proceedings, with no mention of it, this court said that it would be reasonable for the defendant to believe that by repeatedly not mentioning post-release supervision was an indication that post-release supervision was not part of the sentence, especially when all he knows is that it's under the court's discretion, which a defendant who hasn't gone to law school might think he might have discretion not to do post-release supervision. And that's why the Court of Appeals has mandated a clear-based, record-based rule where you could look on the record and it's a bright line rule, and that's worked very well, and that's not what happened here. And so even another reason why it doesn't matter, that the agreement doesn't matter, is I think it was also Cornell where earlier in the day the people made an offer of 14 years and 5 years post-release supervision, and it was clear the defendant rejected the offer. Then the court went back and forth and made some modified the offer a little bit. I'll cap it at 14. I'll give you some consideration. But each time he mentioned it, the court didn't mention post-release supervision. And then and the prosecutor never made clear. The courts, this court said, and it was affirmed on at the Court of Appeals, that the court should have simultaneously made clear that your sentence will be X number of years in prison, X number of post-release supervision. And
I think we have that argument, counsel. Anything further?
No, Your Honor.
Thank you, counsel.
Good morning. To be clear, our position is this is not preserved for appellate review. And the basis of our argument is this agreement, the plea and sentencing agreement, plea and possible sentence agreement that was executed by defendant with his attorney and the prosecutor 2 weeks before the guilty plea was entered. As I made the court well aware, and I made defense counsel aware when I received his brief, I understand the fact that this was not a marked court exhibit, but it was nonetheless relied upon by the defendant in his sentencing memorandum, where he relies on all the work he did in furtherance of this cooperation agreement to try to get a more lenient sentence. And for that reason, it is our position that this is part of the record and subject to review by this court and should be determined in whether or not the defendant's claim is unpreserved. I do also want to clarify, there really wasn't any ambiguity in the plea agreement with regard to the sentence he faced. By entering into this agreement, the defendant also agrees to plead guilty to the violation of probation pending, list the CR number, for which the minimal possible sentence is restoration to probation, and the maximum possible sentence is a determinate sentence of 8 years in the Department of Corrections, followed by 3 years of post-release supervision.
Isn't there a subsequent reference, and I may have it wrong, but a subsequent reference to the cap in a separate portion of that agreement, the 2-year cap? Or was that mentioned by the court during the...
It might have been a prior VOP that he had, because there were, I think this was a second violation of probation.
Okay.
It might have been a prior. I don't see, this is the second page of the plea agreement.
The reference to the 2-year cap at some point is where I think the ambiguity argument comes in.
And I don't think it's the plea agreement that pertains to the one that this court has. And I do have an original that I can provide to the court at any point in time if they choose to see it. I did provide it to defense counsel when I was completing the brief. So he had 2 weeks before he pleaded guilty. He had 18 months from the time he executed this agreement until the time he was resentenced. Counsel accuses the people of speculation. The record is clear. There were security issues here. Defense counsel did not want to speak in open court with regard to defendant's cooperation. He asked to have the courtroom cleared. And instead, they fashioned a remedy where he would do a post-sentencing memorandum. There was clearly concerns. At one point in time, I believe the judge said...
You have to concede, though, that the court could have handled this in a way where the record would have been developed more fully relative to the 3 years and the reason why the cooperation wasn't being put on the record. It could have been done in chambers on the record and sealed.
This could have been sealed. I can guarantee the court there's a lesson learned here with regard to cooperation agreements. I do know, there is an overriding concern about safety, and how these are disclosed.
Do I have the record correct? There were 13 appearances after the plea was signed?
I would not be surprised about the total. I can't say that I counted it, but there were numerous. And, this was his, this case stemmed back, I think, to like 2007.
What were they doing 13 times?
Checking cooperation level. There were numerous prior arrests in other counties for other offenses. That there was, decisions as to whether or not he was going to continue to cooperate, or so it was just they were just watching him. Look, I don't dispute that this individual did some significant work for law enforcement during this time period, during the time period he was under. He was, and they were very willing to work with him. So there was a lot going on, both in his actions while he was out of custody, and also checking on his cooperation. So every time there would be an offense, I don't think counsel would dispute there were many unlicensed operation issues, vehicles in other counties, other towns. They would be notified, probation would be notified, the court would be notified, then everybody would come back in. I can't guarantee you that's what everyone was, but they were back and forth a lot. So it is our position this is unpreserved. He had every opportunity to fix this. If he didn't understand, it's our position he knew, and it should be found unpreserved. Thank you.
Thank you, counsel. Case 63, People versus Fisher. It's deemed submitted. Case 64, Agricultural Development Services versus Rich. Counsel, proceed.
Thank you, Your Honor. Good morning. May it please the court. Plaintiff Appellant Agricultural Development Services, also known as ADS, pursuant to CPLR 5501A1, respectfully ask this court for an order reversing the trial court's summary judgment order that granted the Rich defendants' counterclaims in this matter and accordingly vacating the final judgment dated August 25th, 2022. Respectfully submit that the record in this case reflects that there were several and, more importantly, material issues of fact that would render summary judgment inappropriate and erroneous in this case. And for purposes of oral argument here, if I may focus on the counterclaims 1 and 2 for breach of contract and unjust enrichment respectively, because those were the counterclaims that ultimately resulted in an order for damages. And if I may, I'll take those in reverse order and start with the unjust enrichment counterclaim. As this court is aware from the papers, this case arises out of a failed joint venture between the parties relating to hemp and the attempt to grow and ultimately sell that hemp, which was unfortunately unsuccessful in every respect. In September of 2019, the plaintiffs filed a complaint in Monroe County with, among other causes of action, a conversion cause of action against the Rich defendants. At the close of discovery, the trial court found that there were, and after the plaintiffs filed their own motion for summary judgment on that conversion cause of action, the trial court found that there were material issues of fact relating to that cause of action and the hemp, which was the subject matter of that conversion cause of action. But in so doing, the trial court simultaneously granted the counterclaim for unjust enrichment filed by the Rich defendants, the subject matter of which was that very same hemp that was the subject matter for the conversion cause of action. As this court is aware, the essential inquiry in any action for unjust enrichment is whether it is against equity and good conscience to permit the defendant to retain what is sought to be recovered. It is plaintiff appellant's position here that it would be inequitable and frankly illogical to allow the Rich defendants to recover on their unjust enrichment claim if they indeed converted the hemp that is the subject matter of plaintiff's conversion cause of action. In addition, as it relates to the unjust enrichment counterclaim, I would point out that there are material issues of fact as it relates to how the Rich defendants would be reimbursed. At 2487 in the record, the trial court noted that Representative Josh Cawley from ADS, my client, testified that the Rich defendants' expenses would be reimbursed through revenue only. Whereas conversely, at 1715, Ryan Rich, in an affidavit, stated that it was always understood that the parties that ADS would compensate the Rich defendants for any and all expenses incurred, irrespective of whether revenue was generated. I would submit that that distinction alone, whether reimbursements were guaranteed or to be specifically paid from revenue, presents a material issue of fact, as the product was indisputably never sold, and therefore the counterclaim just simply could not have been granted at the summary judgment phase. Real briefly, as it relates to the breach of contract counterclaim, a review of the record shows that it's incredibly murky as to whether these parties ever had a meeting of the minds in the first instance. But what was clear, and in particular at 1615, was that as it relates to the seeds for hemp that the Rich defendants transferred to my clients, the plaintiffs, that any proceeds from those seeds would be split between the parties. However, as I started out saying, indeed, there were no proceeds. This was a failed joint venture. The record is clear that the farm in North Carolina that ultimately planted these seeds transferred the possession of all hemp biomass back to my client, and nobody was paid any money for services. So there was no revenue. Yet the trial court erroneously found breach and that the rich defendants suffered damages. Indeed, at 2486 in the record, the lower court stated, "What, if any, damages have been suffered by the rich defendants is a question of fact which shall wait trial." So in so doing, it is our position that the trial court disturbingly acknowledged that there is a question of fact as to whether the rich defendants suffered damages at all, but still granted summary judgment on the breach of contract counterclaim.
And it's your argument, without the proof of some damages, that summary judgment would have been premature.
Exactly, Justice Whalen.
I think I understand that. Anything further, counsel?
No, thank you for your time.
Thank you.
Good morning.
Counsel, picking up on that last point, if I could.
Yeah.
Does there have to be some demonstration of damages proof in order for you to get summary judgment on liability, on the breach of contract claim?
No, there just needs to be a determination that there could be damages, and that's left for trial. And we cite the case law in our
Moving forward on a contract breach claim, you could recover nominal damages, could you not?
Exactly right.
Okay.
And let's start with the contract claim. And again, the summary judgment decision was on liability only on both points, so damages were left for trial. So on the breach of contract claim, the undisputed record that the trial court had, and this is all from plaintiff's ADS's testimony and sworn statements, the plaintiff and defendants entered into agreement where defendant gives the plaintiff 60,000 hemp seeds, plaintiff causes the hemp seeds to be planted and harvested, and then they're going to split proceeds, or split whatever the value is of the hemp. What we know, though, is that plaintiff took those seeds and sold them to Carolina Ridge Farms. There's a seed supply agreement in the record.
Does it matter, again, correct me if I'm wrong on the record, does it matter that in order for the grower in North Carolina, I think it was, required title to the seed under state law, that when that transfer took place, whatever was legally required to be done was being done so that it could be, that seeds could be planted, grown, and there could be a harvest in anticipation of whatever profit is split between the parties. Is that not something that could have been properly executed under the terms of this relatively loose agreement?
If it were part of the agreement, maybe, but here's the thing. So they sell to the grower at, what is it, $1.50 a seed, whatever the number is in the seed supply agreement.
Plus a percentage of profit.
Plus a percentage. But then and this was why the court noted where the breach comes in. One, there was that sale of the seeds was a breach. But two, and this comes from, again, ADS's own lawyer, and this is what the trial court relied on. The product that was grown, the ADS folks looked at my clients, Brian, Rich, and defendants, and said, you have to go deal with the grower to get that product. And so it was very clear that full title to everything was transferred to this grower. And that's plainly a breach of what the agreement was. So my client is left with...
So even if we were to say the actions by transferring this seed to the grower under that state law required title to go to the grower, and they have that, your argument is that that's a breach in and of itself.
Yes.
Because there was no, title was being held by your client.
Yes.
In this seed, and if you're going to transfer title, that's contrary to any agreement that we had.
100%.
I think I understand.
But then it couldn't be grown. Am I accurate on that?
Well,
the seeds could, because it was against state law to grow in North Carolina.
I don't know that it is against state law. That's an argument that people have said. There was no proof on that. But more important, so if that's the case, one, it should have been told. And by the way, there were seeds also planted in Pennsylvania where there wasn't, and we don't even know what happened with those seeds. But so, but then two, so what I'm hearing is they grow this product, and now we can't have no access to it. So we've given them seeds. We've received no money. They've received money under the seed supply agreement, and now the grower has kept the product and is saying, and they're saying, we'll go deal with him. We can't give you anything. That is plainly a breach of, yes, maybe loose, but plainly a breach of this agreement. And again, the issue of damages was left for trial, and what the jury did was valued the seeds and awarded the value of the seeds. So then we move to the unjust enrichment claim. And this is a classic case of unjust enrichment. They're talking about a venture, and my clients go out of pocket, and they pay for labor and equipment and materials to process plaintiff's hemp.
And those are the damages contemplated in the unjust enrichment claim, as opposed to the damages on what the value of the biomass would have ultimately been if properly raised and sold.
Correct. So we're talking about two different things. So the breach of contract was on our seeds and plaintiff selling away those seeds. The unjust enrichment is plaintiff has truckloads of hemp they put into a facility, and we expend money for people and product and equipment, and we process this stuff. And the idea, and again, this all comes from their admissions. Yes, we were going to compensate them in some way through the revenues. That was the understanding. Now that breaks down, right? So the joint venture breaks down. But when it breaks down, that's your classic unjust enrichment. Well, we've poured all this money into your product. You need to pay us for those expenses. And that's what the jury awarded. The only defense I saw really on brief was, yeah, but we argued that you stole our hemp, and therefore, if you stole our hemp, then you wouldn't be entitled to unjust enrichment. I mean, two things on that. One, the concept of leaving the issue of damages for trial actually covers that, right? Because then they had their conversion claim going to the trial court. We had our claim going to the jury as well. And the jury would offset those damages if there was conversion. By the way, the jury found there was no conversion. They lost on that claim. There was no product stolen. So then we go to the point here. If you were to look now and reverse the trial court on that portion of its decision and say, okay, well, we think that there could have been a claim of conversion, and that's going to be their defense to the unjust enrichment claim. We know they can't assert that defense because they've already lost that at the trial court. So that reversal wouldn't impact the final judgment. They can't raise that defense.
Thank you, Counsel.
Thank you.
Case 65 and 66, Allen versus Courtney.
Sorry about that. Click the wrong button. Am I coming through now?
Mr. Pelch, we can hear you. Can you hear us?
Yes, I can. Thank you. Good morning, Your Honor.
Hold on a second. Do we have another counsel? Is it Mr. Martin? Are you on also?
Yes,
Mr. St. Martin? Mr. St. Martin? Very good. We can hear you. Can you hear us?
Yes, I can. Thank you.
Very good. Proceed, counsel.
Sure. May it please the court. Don't have a ton to add to this other than what's already included in my brief. This is a custody case wherein the respondent father started a relationship with a woman and wanted to relocate to Wisconsin to be with that woman, and petitioned court to bring his son with him. At trial, the court had a pretty tenuous best interest ruling in which, it relied on the father's new girlfriend's, greater financial stability. I'll defer to Mr. St. Martin's Michael B. update on that, but essentially the court allowed dad to relocate with the child to the state of Wisconsin, removing the child from two half siblings, his grandparents, his mom, and it didn't respect a custodial order that had been in place since 2017.
Counsel, don't we have significant post-judgment facts that have arisen that are pretty important here, don't we?
That is correct, yes. And I can either speak to those or I can defer to Mr. St. Martin, because I think that, he's been in touch with the child, and so however you'd like those to be addressed, I'm happy to do so.
I mean, almost to the point that they kind of swallow up a lot of the argument that's in the briefs initially.
I think that's correct. My only concern would be, I don't know what dad's current situation is. His whereabouts are even unknown, but because he does have primary placement in the prior order, in my client's interest, I'd be worried that if dad, were to show up and reassert his placement of the child, that the court, could give deference to that.
Counsel, are you asking us to reverse and remit?
I mean, my client's trying to get before the court right now, but she's having issues serving dad. But I'll be happy to defer to this court's judgment in that regard.
Very good. Anything further, counsel?
Not unless you have questions for me. Otherwise, I will allow Mr. St. Martin to speak.
Mr. St. Martins, bring us up to speed, please, if you would, with respect to where the child is currently living and what's happened since the proceeding ended at the trial
Yes,
level.
thank you, Your Honor. It's my understanding that the father dropped the child back off in New York at about 2 or 3 a.m. in the morning about a month ago, and advised the mother that he could no longer care for him, and him and the girlfriend had separated in Wisconsin. Since that time, I did speak to my client actually this morning, and I spoke to the mother yesterday, and I haven't been able to reach the father, but the child advised me that he hasn't seen his father since that time, but that they have been communicating by text message. The mother's not exactly sure where the father is currently. She believes he's still in Wisconsin. So there is a proceeding pending in Wayne County Family Court presently that the mother filed once the child was returned here.
And counsel, there is an emergency order in place giving mother custody, right?
That is correct, yes.
Okay, so she has a piece of paper that at this point allows her to assert, that she's the custodial parent until that's changed.
Correct.
Okay, and then you're hoping to go back to the court, and part of, I think, what, we might be considering is making sure you get back there.
Yes, and that would be my request. I join in Attorney Pelch's request that the court remit the matter to the lower court.
Reverse and remit is what you're asking for, right?
That's correct, Your Honor.
Very good. Thank you, counsel.
Thank you. If there's no further questions, I'll yield back the remainder of my time. Thank you.
Very good. Case 67 and 68, Migo versus Migo. Mr. Alderman, can you hear us?
I can, Your Honor. Can you hear me?
And we can hear you loud and clear. Please proceed, counsel.
Thank you. May it please the court, I represent the defendant, appellant Cyprian Mejigo in this proceeding. There is the primary issue, and probably the only issue that is to be determined by this court, and that is whether or not the plaintiff met her burden of proof to establish the marriage that she claims existed between herself and Mr. Mejigo.
Is it your argument, counsel, that her testimony by itself, even if the court found it credible, was insufficient?
Her testimony, yes, Your Honor.
And but if we add to that the attestation that took place when they left the Congo, traveled through Rwanda before emigrating to the U.S. in 1994, is that not additional evidence?
The only evidence, the only testimony was that there was travel by the parties with the children to the point where they were then able to, under the auspices of the Most Holy Rosary Church, be admitted to the United States. There was no testimony as to the relationship that existed in any of the countries that they traveled through in order to get to the United States. And there's no evidence, no presentation of any aspect of any common law or any law that recognized even a common law marriage in any of those jurisdictions. So there's a complete absence of evidence or testimony with regard to that. The only real evidence that was submitted to try to establish a marriage in Africa was this attestation that was in the French language. And as set forth in my brief, there are two problems with the consideration of that. That was submitted into evidence by the lower court over the objection of Mr. Mejigo's attorney. And the difficulty there is the court said that it would receive that evidence and give it very little weight. Those were the actual words that the court below gave, very little weight. Our position is that it shouldn't have been received at all because one, it was in a foreign language and the CPLR requires certain documentation and authentication of the translation of anything that's submitted into evidence in a foreign language. And two, because it was a record of another government, purportedly another government, that there's also the CPR requirements of how that can be received. There is a claim that the court should take judicial notice. There was never any request on behalf of the plaintiff that the court below take judicial notice. And as I understand the CPLR, that requires a notice either in the pleadings or in the alternative, a notice prior to the trial.
Mr. Alderman, did the husband testify that the document said that the parties were married? Wasn't that in the, was that in the record, page 97, 98?
He testified that he obtained a document that is reflected in Exhibit 2. And what he said in his testimony is that he was looking for a document to allow his, the plaintiff to have some element of safety, because this was at a time when there was a genocide by the Hutus against the Tutsis, and the plaintiff was a Tutsi. So his testimony was that he went on the street because he said all the government offices were closed. He purchased a document for $3, and that was what constituted Exhibit 2. But as I'm suggesting, I don't believe Exhibit 2 should have been received into evidence. And even if it were received into evidence, the description by Mr. Mejigo is that he obtained that outside of any governmental entity.
And as you've already argued, in addition to that, the court, in accepting it, indicated that the court would give it very little weight.
Exactly.
I think we understand that argument, counsel. Anything further?
Just with regard to the issue about the ceremony before Father Manara in the Most Holy Rosary Church, Your Honor, and that is Father Manara, in his testimony, could not say that he married the individuals. All he could say was either a marriage or that it was a reaffirmation or a validation of a prior marriage. And he also said that he would not have married anyone without the presentation of a license, and there's no evidence that the parties ever obtained a license to get married. Because of that, our position is that the ceremony that Mr. Mejigo denies, but even if the court accepts that there was some type of ceremony, that it didn't rise to the level of a ceremony that could be recognized by New York court, because there has to be evidence of a solemnization of the marriage. And that solemnization requires under the statute that the parties attest and solemnly declare that they intend to be spouses. There was never any testimony that that ever occurred, either by, in this case, the plaintiff or by Father Manara. So our position is that neither the claimed marriage in Africa nor the ceremony that took place in Syracuse, New York, rises to the level of establishing a valid marriage between the parties.
Very good. I think we have that, counsel.
Thank you.
You should begin to wrap up.
But just that our third point is, in the event that the court does find that the ceremony in Syracuse, New York, in the Most Holy Rosary Church did in effect become a marriage, that the court has to revisit the issue of the duration of spousal maintenance, because the court below found that it was a 28-year marriage as opposed to a 14-year marriage. If the African marriage was not considered to be valid, then it'd only be the one in Syracuse. And because of the shortening period of time and the recommendations in the domestic relations law, the percentage that is advised to be durational would have to be revisited.
We'll take a look at that. Thank you. Counsel.
Yes, thank you.
Good morning. May it please the court, John Sarando for the respondent wife. I think the husband is, the appellant's position seems to be, I'm married to get out of Africa. I'm married to get into the United States. I'm not married when my wife sues me for divorce, and I shouldn't pay any alimony.
Well, I think counsel's argument is if I understand it correctly, that there's no proof in the record that there was a marriage in Africa back in the 1994 period of time, which I directed him to address. He's saying that the proof fails in that regard. And whose burden is it to demonstrate that there was a marriage?
Well, I think when you consider the whole record, okay, and Judge Greenwood indicated something about page 97 and 98, he indicates that this piece of paper says we're married, okay? It's really...
Counsel, you're saying that the husband indicated in the record that the piece of paper, which was the untranslated French document, indicates that they were married.
Right.
But is counsel correct? Doesn't the record also reflect that he said that it wasn't a government document and he bought it on the street for $3? And if we're going to believe him for one part of it, why would we not believe him for both?
I think these people had a common law marriage in the Congo, and under Belgian law, it's recognized as a common law marriage. And I think when you have a couple living together in the Congo as husband and wife and have 7 or 8 children, I think you have what is known or what is considered to be a marriage. And New York, as we know, recognizes common law marriages if it's valid where it started. And this was valid where it started. I apologize for not footnoting the translation of the document in the brief. And insofar as judicial notice is concerned, I think the Court of Appeals in the Gottnick case indicated that if it gets there, maybe it shouldn't be there, but if they've got a chance in their reply brief to respond, then the court will consider it. And I think that's the situation here. And with his indication of it's a 14-year marriage. Even if you take that and you look at the chart, up to including 15 years, you go between 15 and 30%. The judge went to 25%. So even she should have gone back and started when the first child was born, and between this couple and go between 35 and 50, but they didn't appeal. So, but I think the record is clear enough to sustain, for this court to sustain the award as given by the trial court. And if there's no further questions, we'll rely on our brief for all of the others.
Thank you, counsel.
Thank you.
Case 69 and 70, in the matter of Michaela S. Counsel Connolly, can you hear us?
Yes, Your Honor. Can you hear me?
We can, loud and clear. We'll wait for Mr. Paycheck, I think we're waiting on. Ah, here we are. Mr. Paycheck, you're on mute.
Mute. There we go. I'm sorry.
Very good. Can you hear us, counsel?
Yes, I can.
And we can hear you. Please proceed, counsel.
Thank you. Good morning, Your Honors. May it please the court, Caitlin Connolly for the mother. I'd just like to make a few comments on points 2 and 3 of the brief, please. Your Honors, it's submitted that the abuse determination is not supported by the evidence. The record does not demonstrate that the mother was aware of the abuse. Just because she was in the home doesn't mean that she was aware. Likewise, a derivative abuse finding that the son is not appropriate because he was not aware of the abuse and there's no evidence that the mother's boyfriend ever directed abuse at him or that he was at risk of abuse. As for the disposition, Your Honors, by the time of fact-finding, the mother had moved out of the home that she shared with the boyfriend, thereby correcting the condition that had led to the initial removal. At the dispositional hearing, family court seemed focused on the best interest of the daughter, which led to the imposition of conditions which did not necessarily relate to or further the best interests of the son, who was differently situated. Therefore, we're asking this court to modify the order by returning the son to the mother and by removing certain conditions imposed on her which are not tailored to the son's best interests.
Thank you, counsel.
Thank you, Your Honors.
May it please the court. Michaela has aged out. She is now living with her mother.
Counsel, just in terms of order, should we be hearing from the department next?
I'm sorry, I didn't realize they had appeared.
Yeah, not a problem. Thank you, Mr. Pajak. Counsel, please proceed.
Thank you, Your Honor. May it please the court, on behalf of the Erie County Department of Social Services, Benjamin E. Mannion. Good morning. I just briefly want to touch on a couple points as my brief was quite long and I think it fairly addresses the issues in controversy here. I would just like to point out to the court's attention that none of the arguments that appellant advances are preserved for review before this court. I noted in the brief, and I note again, that the motion in limine that was made pre-trial addressed particular issues that were not raised at any other point during the testimony or the admission, of Exhibit 2. I believe that after reviewing the record, the pretrial motion in limine dealt with issues of sufficiency. Namely, the trial counsel believed that there was nobody based on the department's witness list that could actually validate or verify or authenticate the video evidence in question. There was no discussion about hearsay. There was no discussion about any other points whatsoever. Therefore, when that witness, I believe it was the inspector, presented evidence, testimony of the appellant in this case, that she had actually identified both the parent sub, whose appeal is still pending before this court, as well as the girl in this case, Michaela, on the video in which the sexual abuse was depicted, that evidence was not objected to whatsoever at trial. Therefore, the argument that the evidence should not have been admitted is unpreserved before this court.
Well, Counselor,
go ahead.
Wasn't the DVD objected to?
The DVD was objected to after the fact, Your Honor. So there was an objection prior to, which again,
wrote a decision on that objection.
Correct. After the fact, though, Your Honor. So there was testimony taken at trial in which the investigator presented evidence or presented testimony that identified the parties in the DVD. That was not objected to at that time. That testimony was allowed to be admitted. It was not stricken from the record, and it is before the court for your decision and review in this case.
And then what's the point that it became in controversy?
The point it became in controversy was well after the fact when they had made the motion. However, they did not.
And when was that? At the close of proof? Or?
That was after the department rested. That's correct. So, and again, as I reiterate, that point is not preserved before this court, but even if the court decides to reach it on the merits themselves, there was more than enough evidence.
Counsel, I have to tell you, I'm a little bit confused, so bear with me.
Of course, Your Honor.
The idea of preservation is that the court below, very often, the whole purpose of preservation is that the court below didn't have an opportunity to rule on the issue that should have been raised.
Correct.
And the failure by counsel typically to raise that issue, and then, or not to raise the issue, and then wants to raise it on appeal, it seems to be unfair both to the court and to opposing counsel.
Correct.
In this particular case, is it your argument that the timing of the preservation is important? In other words, the testimony was already in your case in chief without objection. Subsequently, the objection is made. The court rules on it. So the court's now had the benefit of hearing the argument and has made a ruling on that. You're saying the court can't do that. Once it's in, once you rest, you're done, and they cannot, it cannot be attacked that way. Is that the argument?
No, the argument, you're correct, Your Honor. There was an objection made. My argument is more to the specificity of the objections that were actually lodged in this case.
All right, then let me drill down on that a little bit.
Okay.
Authentication. Is it your argument that there was no objection to authentication?
At the time, correct, Your Honor, prior to
you resting?
Correct.
Was there an objection to the authentication of the DVD and the information on there subsequently that the court heard and ruled on?
So there was an objection to, not to authentication, but to anybody being able to discuss the DVD or identify the people pre-trial. So before the department's case in chief began, there was a motion in limine that was made that addressed specific concerns. None of that had to do with the concerns that were raised when the department rested. So it's the department's argument that because specific objections and specific issues were raised pre-trial, those issues are what the court should actually view that objection as, not the evidence, or not the motion that was raised afterwards, which I will also raise for this court. There was no identification of any hearsay testimony when that testimony was actually offered in court. Therefore, the trial court had no basis whatsoever to actually decide what was and what was not hearsay, because there was no objection raised at the time.
Once the court made the subsequent ruling, did the department ask to reopen proof on the direct case?
No, the department did not, Your Honor. And again, I would just say that in the totality of the evidence that was offered, going to point to, with the video evidence, including the statement by the investigator that identified the parties on the video itself, as well as the negative inference that the trial judge rightfully derived from appellant's non-testimony in this case, the weight of the evidence was more than sufficient for the trial court to find that the mom, or the appellant in this case, had abused her daughter by knowing and allowing, knowing or should have been aware that the abuse had occurred. There was testimony that, again, uncontroverted testimony, that the investigators during their search could hear throughout the entire house. There's audio in the video that you could hear the abuse itself going on. And again, there was no objection to that testimony coming in. It was reasonable for the court to infer that the appellant in this case could hear the abuse taking place and did nothing to stop it until well after it had actually occurred and this trial was underway.
And in the video, you know that mom is home because she's seen, I think, maybe a minute or two before the abuse occurs.
Correct, Your Honor. That is correct. And also, I will just briefly touch on appellant's point 3. This does reflect the best interests of both Michaela and Gabriel. And to assume that, Gabriel does not suffer harm because he's not the preferred sex of the abuser in this case is outdated and flat out wrong. The fact that he is present and hearing that taking place and hearing that, being suffered by somebody, by his own sister, somebody he clearly cares about, reference in the record that he misses her, would like to have
And counsel,
visits with
do
her.
I understand the record correctly that the abuse is taking place in the living room?
Correct.
Right, in a common room. It's not taking place in a separate bedroom that this young boy doesn't have access to.
That's correct, Your Honor.
Thank you. Anything further, counsel?
Pending your questions? Nothing further. Thank you.
Mr. Pajak, we're going to let you restart.
Okay, thank you. Yeah, there's no question in my mind that Michaela is an abused child. I do have a question whether Gabriel is derivatively abused. On this proof, there's no indication that he knew that anything was going on. He's never indicated to me that he knew anything was going on. And so I'm looking at this case and I'm wondering why Gabriel is at the bottom of this scrum. Michaela is now living with her mother and the maternal grandmother. That's where Gabriel wants to be. He hasn't done anything wrong. And on this record, with the order of protection against dad in place, Why can't Gabriel go back to live with his mom and his grandmother? Now, just this week, and I thank counsel for bringing this up to me, Ms. Connolly, DSS basically withdrew its TPR petition against mom. So Gabriel is now in limbo. He's neither fish nor fowl. He's 15 years old, 14 years old. He doesn't have a credit card, can't buy an Uber to go out and move to grandma's. So he's sort of in the middle until something else happens in family court. And that's my point. We should put a stake through this heart of Dracula and get him off the schneid. His teenage years are going to go by in a flash. Let's not have him in foster care while he's waiting. Now, foster care mother is a very good person, taking nice care of him, but he wants to go home.
So your argument then is about the disposition order, correct?
Exactly.
Okay. Thank you.
Thank you, counsel.
Thank you.
Case 72, Tickner versus Town of Perrington.
May it please the court. Alan Knopf for the petitioner appellant. While respondents asked the court to defer to the ZBA, in this case, deference is not warranted because
Counsel,
it's
I'm gonna
really an
interrupt
issue
you-
of law.
I'm going to interrupt you just for a second, so bear with me. How is this case not moot? Based upon the fact that the lease is expired and the party brewery is no longer in the premises?
Well, Your Honor, the general principle is zoning runs with the land, and it doesn't apply to the particular people, it applies to the property. So they have a site plan.
So if there's a violation by the current brewery that's in that property, wouldn't that be where the action lies now?
Well, Your Honor, the problem is the zoning board has interpreted the site plan to allow this expansion into the second floor and outside on the canal bank.
How can this action bind the brewery that's in there now?
Because if the, and again, the town said they've reevaluated the parking requirements. We have no problem if the ruling of the court is they're stuck with the original site plan that says you can have a tasting room. But the problem we have here is the zoning board made a ruling that it's okay that they expanded to the second floor, and the site plan allows that. The site plan allows them to be on the canal bank. Now, if the ruling of the court is, no, it doesn't allow that, it only allows what it says, that's what our whole case is about. They're only allowed to do what the original site plan allowed. And it had 37 occupants on the first floor, and they had like a balcony, and that was it.
So if we were to rule that way, would it impact the brewery party in this case?
Well, I mean, they wouldn't be able to expand out onto the canal and all
The
that.
brewery party in this case, would they be impacted by our ruling that you're asking this court to rule on?
Yes, whatever, it runs with the land, so whatever ruling.
They're not involved in the land. The lease is over, they're out, they're not even.
I thought you meant the new brewery, I'm sorry.
No, I'm talking about the brewery party that is in this case.
No, I mean, they would be out of it, and it wouldn't really affect them. That's over.
Doesn't that make this a moot case for this court? Because our decision wouldn't impact the party to the case, and in fact, I think you're arguing that it should impact the current brewery that's in there now that is not a party in this case.
Well, it impacts the landowner who is a party. So
Shouldn't the brewery party that's in there now be present in the action to be decided by this court?
Well, they have a right to intervene. I mean, we don't have to go out and add every time they get a new
So you're saying they're not a
tenant.
necessary party?
The necessary party is the owner. And we commenced this case like, I don't know, 2 years ago. They weren't around. I mean, if they just get a new tenant, if you have a zoning violation on an apartment house, do you have to go and add every new tenant? No. It runs with the land. That's the whole point. Zoning runs with the land.
We have your argument on the mootness. Thank you. Do you, anything further?
Well, I mean, on the merits, the site plan requirements, if you expand new construction, you need a new site plan, and a landowner's required to comply with their site plan. Here, they had a site plan that allowed 37 people indoors on the first floor.
Right, but as to Justice Whalen's point, isn't the site plan specific to the tenant? That's who site plans are for.
The site plan is specific to the property.
But it's specific for the use by the tenant, isn't it?
No, it binds the land. I mean, the tenant may have been the applicant, no, actually, Mr. Zachman, who was the principal of the landowner, was the applicant. So really, the landowner made the application.
For the use by the tenant, though? No.
Right,
Yes.
right, for a brewery, for a microbrewery tasting room. That's all they're allowed is a microbrewery tasting room.
Right. That specific tenant wanted, though, your client.
True, but again, I go back to if it's an apartment house and I added another unit, the fact that one tenant left and a new one came in doesn't make the case moot. Because, I guess I said it 5 times, because zoning rules of the land, I'm sorry.
We have that idea. You're addressing the merits, so let's stick with the merits.
Yeah, and then as far as it's undisputed, they've expanded the second floor. The planning director even said, yeah, they weren't supposed to do that. He said that at the hearing, you've got to keep your property in compliance. And they've added outdoor seating. The code says, well, if you were a restaurant, you can go to the planning board and add up to 90 seats outdoors if the planning board approves it. Well, first, they're not a restaurant because they don't serve food, but, okay, say they're a restaurant, you can have up to 90, an eating area, not drinking area, for 90 people. But it didn't happen. They didn't go to the planning board. And they say, oh, they're temporary seats. Well, what outdoor area in this climate isn't temporary? I mean, they're saying, I don't think they're going to be open today, but our concern is come July, if a lot of people come to this brewery, they're going to open up and be out on the canal area. And again, my client has no problem with the brewery. They're not objecting to the use. Their problem is they were overrun with parking. And the respondents say, well, you didn't prove that all these cars parked on 96 and all over the creation came from the brewery. Well, the evidence showed that, but we don't have to prove that anyways. The point is, if you expand, you got to meet the parking requirements, and this was a significant modification to the site plan. I cite the Ferrari versus Town of Penfield case that I had maybe 30 years ago for the same principle. As far as the parking, I won't go through all the stats on the parking, but they were supposed to have 48 spaces based on, the 37 people, but they're way beyond that. They admit 120 seats, and we said 185, but if they're at 120, they're nowhere near compliant with the parking requirement. I won't go into the specifics, but they also say, well, Mr. Dozier wasn't aware of all these facts, so we can only go on what the zoning or the planning director had in front of him when he made his decision. Well, that's just wrong. Why did the legislature require a public hearing in front of the zoning board if you couldn't bring evidence in? So clearly, the zoning board has the power that the administrative official had. And if there's new evidence presented that he didn't know about, or frankly, it was in our original letter to the zoning or the planning director, the zoning board can hear that, and it really was undisputed about the expansion. So we have a real problem with the parking. I do think that based on the zoning board's ruling, they could go and put people out on the canal in this area and put 100 people there that they've been doing, causing problems. They've got to find parking. If this court's ruling is no, they can only have 37 people indoors and that's all they can do, great. We're all for it. Thank you.
Thank you, Counsel. Who's going first?
I'll defer to Mr. Lefebvre.
All right, very good. Proceed, counsel. It's who filed first, their briefs, but go ahead.
The court addressed most of the town's arguments. I would point out that in July of 2023, our planning director did send a letter to the new tenant saying if you wish to expand beyond the previously approved site plan from 2018, you do have to go back and get new site plan from the planning board, et cetera. The town is currently attempting to address some of the parking issues. I don't know if any of you have ever been in the Bushnells Basin area. It's a historic hamlet. It's very crowded. Parking's an issue for everybody. They are currently trying to negotiate with a private property owner directly across the street from the brewery to see if they can perhaps construct a municipal parking lot. That's essentially what this boils down to, is a parking dispute. Really, I think you addressed most of the questions that I had. One final thing, I would like to thank Mr. Knopf and Mr. Reffermat. They were unbelievably helpful to me. I've never been before this court, and they went out of their way to be decent to me, and it was very much appreciated.
I'm not surprised by counsel. Thank you.
Thank you.
Yep. Proceed, counsel.
Thank you, Your Honor. May it please the court. And thank you for raising the threshold issue of mootness. Unless there are any questions, I don't think we need to delve back into that. But I would say it's important to point out that the mootness issue also encompasses, we would need new findings. There are no findings about this particular tenant who's been in there for many months now. The 120 that has been bandied about, that is also moot with a lowercase m. The reason is they're not seating people outdoors anymore, even in the summertime, or when weather permits. They are not seating people outdoors. So the occupancy inside has plenty of parking, and that's clear from the record. To the extent that there were disputes in the record about that, that goes to the competence of the ZBA. An appellant, the Wealth Trust, is asking this court to sit as a super ZBA, or a super town planning director. And obviously that is not permitted. Unless there are questions, I think I'm...
No questions, counsel.
Thank you.
Thank you. Case 73, Fallon versus Five Star Management Services LLC et al. Counsel, I believe the appellant has submitted. Do I have that right?
That is correct, Your Honor, I believe.
And you've reserved 10 minutes. Do you want to proceed?
Well, Your Honors, I believe this is a relatively discreet and straightforward issue. We briefed it, I believe, thoroughly in our brief. I am, however, here and happy to answer any questions the court may have.
No questions, counsel. Thank you.
Thank you.
Case 74, Henry versus the Town Board of the Town of Manlius. Counsel, if you'll hold on just a second. Counsel, can you hear us? You're by video?
I can, Judge. Can you hear me?
We can hear you beautifully. Thank you very much. Counsel, proceed.
May it please the court, good morning. My name is Dirk Adamo, and I represent the taxpayers who are the petitioners in this case. I believe that the court has to fully contemplate the sequence of events here so that we get the right application of existing law to these facts. So if I may briefly summarize them. In the year 2020, the end of the year, Town of Manlius and a solar company enter into a contract for a solar farm. Because they didn't do it right then by giving public notice that that type of a transaction is subject to permissive referendum, the town board redid their approval of the contract in April of 21. Now, what's important in the case is the fact that when they did it that time, they put out the proper notices notifying the public that there was a right to a permissive referendum, and no permissive referendum was called for. And you will note, and specifically on page 18 of the record, the petitioners state that the reason they did not, at that point in time, call for a permissive referendum is because they had great confidence in the planning board of the town of Manlius that it would do the right review of the project and identify and work out any of the concerns that these taxpayers who live in the neighborhood had about this project. And they relied upon existing law, which said the planning board must review the project and grant a special permit and ultimately site plan review and go through seeker and all the other things that are required in that process. That's why they say they did nothing at that point. They relied upon the board and its prior history of having reviewed a half a dozen or more solar farms, so they had seen the extent to which the planning board had done its job in consideration. Thereafter, in the fall of '21, the solar company makes its application. Public hearing is held in several appearances, and then just before the planning board was about to make its decision, they found out, the solar farm found out, we don't know how, that the planning board was not going to approve this project. They withdraw on February 14 of '22 their application. What happens next? The town board on February 23 holds a meeting in which it offers for consideration an amendment to the applicable law, which removes the planning board from the approval process of this project. Their position is, this is publicly owned land, we know best for the people, we're going to eliminate the planning board and we'll do what should be done for the protection of our residents.
Was it this project or this type of projects? Was it this particular project only when they passed this legislation, removing from the planning board, or did they do like
No.
town-owned or solar?
No, no. This was specific to the solar statute within their regulations, limited.
But it wasn't, just to clarify with Justice Greenwood's question, it wasn't with respect to this project. It was with respect to this kind of project.
That is correct.
Okay,
You're
very
correct. It was broad-based. It was not as specific to this project.
Very good.
And
All right.
Counselor, wasn't it also regarding property owned by the town too?
That was the amendment that they put in. In other words, they said, we will exempt all solar projects from the review by the planning board for site plan and special use permit only as to property owned by the town. All other projects have to go through this process.
Okay, thank you.
Thereafter, the public hearings in March, or next month, I was there, a lot of people were there. In any event, the town board approved it, and a month after the town board approved it, with no other meetings in between where the matter was discussed, the code enforcement officer issues a building permit for the project. Now, I say the decision in this case as to whether or not that amended statute is applied to this contract or only to future contracts is a very important part of what this court has to determine. I've cited the Court of Appeals case. I'm sure you're well familiar with it, but it's my belief that the town board did not, in its local law, specifically provide that this was to be retroactively applied. This is a transaction.
Counsel, let me ask a question. I'm sorry to interrupt you, but
Yes.
the petitioners aren't parties to the lease itself. You'd agree with that, right?
Yes.
Right. And so do the petitioners have any rights under the lease?
No.
And does that impact how we decide this case, or should it?
I do not believe so, because I say what the issue here is coming back to whether this should be applied retroactively or prospectively. The cases that I reviewed indicate that one of the things, in addition to a clear expression of intent of the legislative body, is whether or not there are vested rights that may be abridged by the new legislation if otherwise the court's trying to figure out what the legislature intended. The vested right in this case, I say, was the fact that the taxpayers relied upon their planning board to do the right job and gave up their right for a permissive referendum. So that is the vested right that I think the court must take into consideration. Because once the town board amended the statute, taxpayers had nothing they could do. They could go to a town board meeting, but they couldn't do anything. They had no process. They had no way to give input regarding the impacts of this project upon them and their neighborhood.
We understand that argument, counsel. We'll take it under advisement. Anything further?
Well, I think the other factor is should you feel that this amended statute is properly applied to this contract, I say to you the town board did not do its own due diligence as put into the statute that they amended. In other words, they said planning board's out, but we will and shall consider the following things. We don't know what they did. All we know is all of a sudden, about a month later, building permit is issued. There's no resolution by the town board authorizing the building inspector, code officer, to issue that building permit. And I say that's a necessary part. And whether your experiences are this or mine, mine tells me that whenever there's an application by a non-owner to do something on a property, the property owner's consent must be obtained. There's nothing in the record that indicates the town board consented. All we think that happened is the supervisor went into the code officer and said, okay, issue the building permit, we're all set. Town supervisor can't do that.
There's nothing in the record about that, right?
Well, I think it's implicit in it. Thank you.
Thank you, counsel.
Appreciate it.
Good morning, Your Honors. Daniel Spitzer on behalf of Abundant. My colleague for the town will follow me. What I think is going on here, I may respectfully suggest, is an improper confusion between two separate powers of a town board. Under the state constitution and under section 64 of the town law, the town has authority over its own property. That's the lease. It also has authority under the statute of local governments, the municipal home rule law, and particularly Article 16, to zone uses, including the property that it owns, but all property. And the process, the 27.2 section that we're talking about, is a zoning statute that has absolutely nothing to do with leases before or after the change. And I know Judge Gilbert said once it was done, he wrote in the opinion, once it was done, the planning board had no role in the lease. The planning board never had a role in the lease, and the prior statute's in there. Simply put, let me first note, to the extent that this is a challenge to the lease, it is time barred. Even if we take paragraph 18 of the petition, which is their timeline that was just laid out so eloquently, it still, as Judge Gilbert pointed out, was filed too late. And therefore, any challenges to the lease itself, to the contract, are time barred. But even if you look at the substance of the lease agreement, nothing in this statute changed anything about the lease. The planning board did not have authority to say, we're not going to approve this project because we don't like the lease agreement. That's simply not subject, it's not in their domain. What they had was the right to issue certain permits. that the town board exercise its right to decide what the process was, and as the court pointed out, for all projects on town property. This happened to be the only one at that time, but it was a category of changes that they wanted control over as the only body that truly is responsive to the voters. Now, it said that, well, they relied on the fact that the planning board was going to act. Well, they certainly didn't rely on that as to the lease, because the planning board had no role in the lease. The lease was done and gone. Therefore, they could not have waited on the referendum right, but they certainly had no vested right in that process. This is Rogers versus Village of Tarrytown, which, interestingly enough, Rogers was a case where a neighbor complained about the change of another neighbor's zoning. And the Court of Appeal said, no, zoning is not static. And these neighbors never had any right, as you reference, Your Honor. They had no rights in this lease. And while they had standing to bring this case, if it was a seeker or other zoning type case, they certainly don't have rights to challenge the lease, and they are not parties to this agreement. The application, which is what the board changed the process on, would have had to follow the new rules, whether it was withdrawn or not, and then resubmitted. And that's because we did not at Abundant yet have a vested right. We hadn't finished, we hadn't started building. So under the Orangetown v. McGee standard, we didn't have a vested right. So that new process would have applied to us whether the application had been withdrawn from the planning board or not. The town has a right to set the process for ongoing projects that have not received a right. And the petitioners respectfully submitted did not themselves have a vested right, because you don't have a vested right in zoning, and certainly not in someone else's zoning. Therefore, we believe the court should find, as Judge Gilbert did, that everything was enacted properly. We also believe that Judge Gilbert properly ruled that the code is very clear that the building inspector rules on building permits, not the town board, not the town supervisor. Can I answer any questions from the court at this time?
No questions, counsel.
All right. Thank you for your time, Your Honor.
Thank you. Counsel?
Judge, I believe Mr. Spitzer hit most of the points that I was going to communicate to the court as well. From the town's perspective, this is simply, there was a legislative amendment that was passed by the town board in March of 2022. As Judge Gilbert correctly stated, a legislative act is entitled to a strong presumption of validity, and the appellants did not meet their burden to rebut that presumption. Regarding what happened after the local law was passed and the amendment was passed, none of the items mentioned by Mr. Odemel or appellants were actually litigated in the underlying action. So those are raised for the first time on appeal. And actually, if you do look at the record, even if it were raised in the underlying action, if you look at the record at page 267, under the amendment, the required documents were submitted to the town board and considered before the building permit was issued. So if there's any questions, I am happy to answer them, but if not, we would just ask this court to affirm the lower court's decision.
Very good. Thank you, counsel.
Court stands in recess.